All right, the Committee for Judiciary and Hawaiian Affairs. This is Tuesday, February 23rd at 2 p.m. and conference room 325. First on the agenda, we have HB 568 relating to sex trafficking. First testifier is the Attorney General's Office. Here.
Aloha, Chair Nakashima, Vice Chair Matayoshi, and members of the committee, Deputy Attorney General Fashad Talebi, and I'm the State Human Trafficking Coordinator. Thank you for allowing me to testify today. The department stands on our testimony that was previously submitted, and I'm available for any questions. Thank you.
Okay, thank you. Next, we have the Office of the Public Defender, Lee Hayakawa.
Hi, good afternoon, Chair, Vice Chair, members of the committee. My name is Deputy Assistant Public Defender Lee Hayakawa of the Office of the Public Defender. The Office of the Public Defender respectfully opposes HB number 568. We will be standing on our testimony, and I am available for questions as well. Thank you.
Okay, thank you. And last, we have Deputy Prosecuting Attorney Tricia Nakamatsu.
Good afternoon, Vice Chair, Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Office. We do support the bill. Our written testimony notes certain amendments. We're particularly supportive of the addition of the term coercion. As our written testimony indicates, there are times when we have actually been told by the court that the existing terms don't cover the situation that we're facing. And of course, coercion is also included in the federal definition already. The term consideration, we feel, this is the amendment we suggest, is that it would be better replaced by something fee or anything of value. Just because the term consideration can get a little confusing, and rather than add further definitions into it, we feel that something like plain language that's easily understandable, such as anything of value, would be a good term to use there. And then finally, we would suggest removing that subsection 3, consent to sexual conduct should not constitute a defense for this violation. That is for technical reasons. We just don't feel that it's necessary. If you have any other, and the state of mind was the last thing that we wanted to note, that the solicitation of a minor currently is intentionally, knowingly, or recklessly. And of course, recklessly is a lower state of mind than knowingly, which is the state of mind for sex trafficking. So we'd appreciate if the committee would take that into consideration. And it is, we're available for questions, if any. Thank you.
Okay, thank you. That's all the questions we have. Members, any questions? Representative Nakamura.
Hi, I have a question for the Attorney General. So I think in your testimony, you mentioned that you believe a bill that we're going to be hearing later on, HB 887, is more comprehensively covers these, what's in this bill, HB 568. So I just wanted to get your thoughts on that, and if you can expand on that.
Yes, thank you. There are some significant legal issues. One of them that has to do with the current solicitation of a minor for prostitution charge, and the way that this is currently written, and even though it's moved into the trafficking statute, I think it still presents some issues. I think we address that better in terms of our amendment for it. We don't have a strong position about moving it into the sex trafficking statute. It is consistent with the federal law. I do think there's value to having a separate offense, but I think it's more appropriately should be commercial sexual exploitation of a minor. And along with some of the other amendments in our bill, I know it is long and comprehensive and extensive, but I think the updated language is very important. It's very important in this space, both educating jurors and then also just the community in general. And so when we looked at this, I know there's several sex trafficking bills. I know there's commonly at every session, there's sex trafficking bills. And so the thought was, let's do kind of a comprehensive revision that fixes the legal issues, but then would kind of bring our statutes up to the forefront in terms of best practices. So again, there are things in this bill that we do support. And I think we also include those in our bill. So if there's anything else specific, more than willing to answer.
Thank you.
Okay, thank you, members. Any other questions? Representative Ward.
Also to the sex trafficking coordinator.
Yes.
How long has that office been established? Actually, I was not actually aware there was a sex trafficking coordinator.
Yeah, so General Connors, this is a priority for her. I started in May of this last year, and so I think what was identified was kind of a lack of the big picture statewide leadership. And so at this time, obviously, given budget restrictions, we weren't able to kind of start with a unit or a program. And so we're really just utilizing the resources that are here, and then our community partners, stakeholders, prosecutors' offices, and law enforcement agencies. But we hope to build it up both through, we know the realistic state budget situations, but hopefully through some federal grants and other ways, I guess,
And your
to be resourceful. But what's that?
And what is your mandate? Your raison d'etre, if you will? Is it to eliminate, lessen, etc.? And I got a specific question about that.
Yeah, so it's actually human trafficking in general. So that'll include labor trafficking, international types of trafficking, as well as adults and children. And so the position, we've defined it as kind of policy-based. I'm in the criminal justice division, so prosecuting cases, and then also just providing that statewide coordination.
The bill, as well as the Office of the Public Defender, quotes HB 568 to target approximately 150 establishments that participate in the commercial sex trade in the state. Are there 150 establishments in the state of Hawaii that you know of, that as the coordinator you're aware of?
I will say, in terms of establishments, what we generally see is what I'd refer to as storefront brothels. So those are more of an international based trafficking, illicit massage parlors, spas, residential brothels. I think based on kind of an open source analysis from some national partners, I think they had identified about 90 of those in Oahu alone. And then data in terms of domestic trafficking, we do have some figures from Child and Welfare Services in their hotline and some service providers, but something that's a priority for me is really trying to collect that data. And we have another bill also trying to codify the program that includes providing legislative reports that will do an assessment and try and provide more empirical based data to support some of our recommendations in the future.
My last question is, what is the actual, how would you say, the numbers that, are we the last or the first in this, the first top 5 in the nation for sex trafficking? I mean, I've heard, I don't know if it's a substantiated rumor. Where are we on the national ranking of sex trafficking is the question.
I mean, I would say it's anecdotal. I think all states are struggling with it. It's what's, I guess, unique and distinguishes it from maybe sex offenses is it's a market-based crime. So it's driven primarily through profit. And so I would say in terms of our response, we can probably have a stronger response, but I don't know too many studies that have ranked specifically who has a worse problem, but I will say it's prevalent here, and it's prevalent in all our counties and all the islands. So it is something, again, that General Connors has prioritized, and that we are going to be proactive in terms of addressing.
So there are many sex trafficking coordinators like yourself in the other states.
Yeah, so it varies. I was actually in a previous role in Washington State, and I headed the Human Trafficking and Child Exploitation Unit at the Washington State Attorney General's office. So I was a county prosecutor for about 10 years and specialized in prosecuting cases, and then went and started that unit, and it was a lot more policy-based, but very similar. And so that's why I was brought in, I think, to kind of use that experience and provide a similar type of leadership at the AG's office here. So
Thank you for immigrating, and we wish you well.
thank you.
Thank you. Any other questions, members? All right, seeing none, moving on to HB 169 relating to disorderly conduct. First up, we have the Office of the Public Defender.
Aloha, Chair Nakashima and members of the committee. My name is Darcia Forrester. I'm a Deputy Public Defender. I'll be testifying on behalf of Mr. Tabe. The Office of the Public Defender submitted written testimony in opposition, but we wanted to emphasize that this measure is not needed to address the concerns in the preamble. There are numerous ways for law enforcement to address this particular issue through existing criminal statutes, and this proposed measure we feel will violate State versus Modica and State versus Sasai, which is outlined in our written testimony. And I'm available for questions. Thank you very much.
Okay, thank you. Next up, we have Honolulu Police, Mr. Kunishima.
Good afternoon, Chair. I'm Michael Kunishima, Captain in the Honolulu Police Department, Criminal Investigation Division. The Honolulu Police Department stands on its written testimony in support, and we're here for any questions. As contrary to what the public defender says, I think it'll give the police department an available statute to address all the threats at schools that make false or misleading threats. So we'll stand on a written testimony, and we're here for any questions. Thank you.
Okay, next, we have a bunch of individuals that submitted testimony, but the only one scheduled to be here is Goldie Wallingford.
Not present.
Who is not present. All right, members, any questions? Representative Ward.
Thank you, Chair. The public defender, please. In your opposition, you basically suggest or imply that this is probably about social media posts. Is that exactly the case? What's the context of the origins of this bill? Because I'm not sure I can see the correlation between orderly conduct and basically lying or distorting or doing stuff misleading.
I believe that this is a version of a bill that's been around for a couple of years. And one of the concerns we had was how it would impact minors who are possibly posting online what would be considered inappropriate content having to do with false or misleading information. So we were concerned about the treatment of this when it comes to juveniles, and making sure that we're not criminalizing behavior that maybe can be addressed in other ways, like diversion programs and just other ways to manage teaching young people how to post responsibly.
Do you have an example of what they would post that would fall under this particular bill?
Well, in terms of seriousness, or are you asking about what we interpret for serious things or for non-serious?
Well,
I'm sorry.
Whatever this bill is prohibiting, let me hear what it says that you're going to say that should not be said, that this bill will no longer be able to be done.
We should ask the police now.
I'm not sure if I understand your question. I apologize.
HPD, do you understand what I'm saying? Give me an example where this would be an offense. What would the offensive, misleading, and define disorderly conduct?
Perhaps maybe like a bomb scare, or that would be a serious. That could fall under this definition, but that could also fall under the definition and be criminalized in current existing statutes. So maybe something like that, or like a false claim that there was an active shooter, but that can be prosecuted under other statutes. So that's what we were thinking.
HPD, could you pick that up and run with it? An example of what this would prohibit that's out there that now is evidently a danger that calls for a bill like this?
Yeah, so currently, when there are either threats made at school or postings that there's going to be an active shooter, don't come to school, the student may post pictures of them with weapons or something like that. It doesn't fall into the true threat criteria for terroristic threatening. And basically, we don't have any statutes to address it. Even a basic harassment, like who does that harass via the internet? So at least with making that a disorderly conduct, we'll be able to enforce a law, get the juveniles the help that they need through knowing that their actions are illegal, and it can cause large, widespread effect for the law enforcement because they have to send additional resources to the school to make sure that the parents and students are safe, and then extras. Teachers and staff to make them feel safe. Yeah. So, and all of that is for nothing if we're able to identify the suspect who posted these threats, but we aren't able to arrest them, or charge.
Thank you. Those are good examples. But what about the more nuanced example when someone says, hey, we're all going to die if you take a shot of some company's vaccination or some other kind of stuff that's out? Who determines what is false and misleading if it's highly nuanced? Whether a bomb scare, your example is very well taken, but if people pick this up and run with it with other kinds of things that are scientific or political and they're really kind of skewed, of which is maybe conspiratorial, does this catch them also?
I think this was meant to specifically take the laws for false and misleading statements for educational. They do say it's for law enforcement or educational facilities. So those would be more tailored for those offenses, Representative Ford.
Primarily for young people and for their possible threats to their fellow schoolmates. Very interesting. Thank you very much, HPD, and thank you, Chair.
Members, any other questions? Okay, if not, we'll move on to HB 170 relating to theft in the second degree. First up, we have from the Office of the Public Defender, William Bento.
Thank you. Thank you, Chair and Vice Chair. William Bento from the Public Defender's Office. We oppose this bill, and we will stand on our written testimony and be available for any questions. Thank you.
Thank you. Members, that's the only testifier we have for this bill. Members, do you have any questions? Representative Nakamura.
For Mr. Bento, I just wanted to say, are you saying that there's already a penalty if you take a bag or a container already on the books, and are you basically saying that this is not necessary?
Well, we're saying yes. I mean, we do believe that the purpose of the bill would be to arrest and charge people that steal something of value. So if you steal a wallet or a purse and it contains ID, credit cards, cash, of course you can prosecute the person for those particular items. What this bill hopes to do is to just prosecute somebody for merely taking, it could be an empty purse or an empty wallet, but it's so broad in nature that you could be charged with stealing a paper envelope or a manila envelope, or something, as we say in our written testimony, contains items of personal value. So, people store items of personal value in almost any type of container, and stealing that thing that could be worth pennies results in a felony arrest and possible conviction. So we don't believe the bill seeks to do what it hopes to do. And it's overly broad, and we feel that it will result in people being arrested and charged and possibly convicted of a felony offense that's unnecessary.
Thank you for clarifying your position.
Yes, thank you.
Members, any other questions? All right, if not, we'll move on to HB 171 relating to property crimes. First up, we have the Office of the Public Defender.
Aloha, Chair Nakashima and members of the committee. The Office of the Public Defender stands on its written testimony, but I'm available for questions. Thank you very much.
Yeah, thank you. Next up, we have Hawaii Pawnbrokers, Jonathan Spiker.
Hi, good afternoon, Chair Nakashima, Vice Chair Matayoshi, and committee members. On behalf of the Hawaii Pawnbrokers Association, we respectfully oppose this bill. This bill proposes changing the state of mind required in HRS Section 486-M by removing knowingly. Removing the knowing state of mind as an element of the offense means a pawnbroker or secondhand dealer will be punished for inadvertently receiving stolen property or for making an unintentional and inadvertent clerical error. And all of that can result in a misdemeanor, which is punishable by up to a year in prison. For example, HRS Chapter 486M requires that every pawnbroker and secondhand dealer document the name, home address, telephone number, date of birth, height, weight, eye color, hair color, age, and get a fingerprint and driver's license or government issued ID for all customers. That's very extensive. A complete and accurate description of all items purchased or pawned, including markings, names, initials, inscriptions, as well as the fineness and weights of precious metals and gems must also be documented, in addition to a price for every item purchased or pawned. So this documentation is often 3 to 4 or more pages, and then once completed, the documentation is transmitted to the police department. So under this bill, if a pawnbroker or secondhand dealer mistakenly forgets to write down any of the aforementioned information, the pawnbroker or secondhand dealer can be charged with a misdemeanor and faces up to a year in prison. And we believe that's not the spirit of the law to charge people with a crime for clerical errors and honest mistakes. That would be like a police officer who mistakenly forgets to write down the hair color of a suspect being charged with a misdemeanor. So in closing, I would like to say that this bill will not benefit law enforcement. Rather, this bill will result in employees of small businesses being charged with misdemeanors and facing possible prison time. This bill creates a crime when none exists. So we believe the Hawaii State Legislature supports small businesses, and we support law enforcement, but ask that you do not pass this bill. Thank you.
Yeah, thank you, Mr. Spiker. I see you're scheduled to testify again on behalf of Hawaii Gold and Silver Company. Do you have anything additional to add, or do you rest on that testimony you just?
If I could give a brief statement, I guess on behalf of my father for Hawaii Gold and Silver. He normally comes, but he's elderly and not in good health. He just would like to say that my name is John Spiker. I'm the owner of Hawaii Gold and Silver and have been in business for over 40 years. I usually come down and I've been giving testimony at the Hawaii State Legislature since 1981. I oppose this bill because this bill implies that large amounts of stolen property are sold to pawn shops and secondhand dealers, and that's very misleading and inaccurate. Pawn shops and secondhand dealers are very heavily regulated as it exists. In fact, less than 0.1% of stolen property is found in pawn shops and secondhand dealer stores. And that statistic is actually both supported nationally and locally, and it's been consistent for many years. And we believe changing the state of mind, the current state of mind as knowingly is fair and just. To change the state of mind to add recklessly does not make sense. In other contexts, it may make sense, but for this context, it does not make sense. So in closing, we just would like to say that there is no incentive for small businesses to buy stolen property, and we believe pawn shops and secondhand dealers comply with the law. For Hawaii Gold and Silver, my business personally, in over 40 years of business and between 30 and 40,000 transactions, I've only encountered 8 stolen items. The heavy burden this bill places on business owners is not rationally related to a decrease in property crimes sought by this bill. So I respectfully submit this testimony and thank you for your serious consideration to not pass this bill, which we believe unfairly affects our struggling pawn and secondhand dealers industry. Thank you.
Okay, thank you. Next up, we have Come Ein Alone, Richard Dan.
Okay. Aloha. Thank you all for allowing me to speak. I appreciate your service. You have my testimony. I want to add to my testimony. I've been a pawnbroker longer than Mr. Spiker for 46 years. I've been testifying before the legislature for that time. I've been in business in the state for that period of time. And I want to explain to you that this new law is an industry killer. No employee will work for me if they think if they don't dot an I or cross a T or have a serial number and transpose two numbers, they could go to jail for that. Nobody will work under those circumstances. That's insane. I wouldn't work under those circumstances. It's an industry killer. The pawn industry is really necessary in the state of Hawaii. Governor Ige considered the pawn industry an essential business during the COVID virus. Approximately 30% of the people in the United States are unbanked. That means they only have us to do their banking. In Hawaii, it's greater because of all the migrant workers that come in. This is a very serious bill. This is a big mistake. By taking out knowingly, it puts everybody who works in a reputable pawn shop at risk. There's no reason for this. I've done a significant amount of pawn transactions throughout the state of Hawaii over the last 4+ decades, and I can't remember how a minuscule amount turn out stolen. We report everything. We take pictures of the people. We take thumbprints. We do everything possible to identify the merchandise so the police have a good chance of getting the merchandise back to the victims if it's stolen. We also report electronically almost on a daily basis to the police department, so everybody knows what's going on. You have a lot of people who are unregulated. Why overregulate the regulated? You have antique stores which should be regulated that aren't. You have secondhand shops that should be regulated which aren't. You have consignment shops which should be regulated which aren't. What you're going to do with this law is punish the people who need the pawn shops. Your constituents, figure 40% of your constituents are not going to be able to get money because pawn shops are closed. That's what this bill is going to do. It's not fair to the pawn shops. It's not fair to the public. Please defer this bill. Thank you very much. Please defer the bill. I have nothing more to say. I'll be here for questions.
Questions? Representative Ward.
Mr. Dan,
Yes.
I was going to ask the question of who primarily are your customers, but you just said 40% of the population is unbanked in Hawaii. Is it that high actually or higher? That seems like an awful lot of people.
The 30% of the United States of America is unbanked. I'm assuming that Hawaii has a greater amount because of all the workers that come in from all over the place to work at the hotels, to work here, to work there. But the national average is 30% of the people in the United States are unbanked, period.
And are they generally low income, medium income, or everybody income who comes as customers?
Everybody income.
Everybody, okay. The rub seems to be that the word knowingly, or the state of mind, removing the state of mind may have negative effects. If that knowingly is put back in the bill, would that be satisfactory? And you
knowingly is knowingly is the only change they're making to the bill.
So it becomes moot then if knowingly is put back in, or it's taken. We don't need.
Then just defer the bill.
Okay, that seems to be a simple enough solution. Otherwise, here's the last question. Pre-pandemic, post-pandemic, or during the pandemic, are you guys up or down in your business?
Nationwide, I'm on national boards. Nationwide, pawn transactions have fallen off. Apparently, people have a lot of money. The amount of money that we have out on loan during pandemic is less than we had pre-pandemic. We're starting to see that come back up again as money gets tighter again. But that's basically it. Our sales are up. During pandemic, we sold lots of TVs and lots of guitars for people who are staying at home. But people weren't borrowing much money during the pandemic. We all anticipated they would be, but they didn't. In fact, they picked up a lot of their pawns during the pandemic. But now it's starting to come back and our pawn bases are growing again.
That is surprising. In fact, counterintuitive. I thought it would be where the pandemic would cause you to just flourish. Very interesting. Thank you for that fact. And thank you, Chair.
Any Representative Tokioka?
Thank you, Vice Chair. Is anyone from HPD there?
If you hit F1, it'll.
What's that?
If you hit F1, it'll get rid of the.
I did.
Okay.
I hit F1. Is
Someone help him?
Hello?
Hello, Chair. This is Captain Kunishima with the Honolulu Police Department. Unfortunately, I'm not here to testify for that bill, but I know that the HPD supports this bill.
Yeah. Hold on. Yeah, so I noticed it was an HPD initiated bill. So, but you're not here to testify on this bill.
Yes, that's correct, Representative.
Because I'm sure you heard the testimony, right?
Yes.
Okay, so if it's as simple as that, I was just trying to see if somebody from HPD could say you were okay with the amendments, but the amendments would be no change to the bill, and that would mean we don't need the bill. So if there was something that HPD could at least come back to the committee, because you know what the pawn shop owner said, made some sense, but I'm sure that you guys wouldn't have introduced this bill if there wasn't a reason. And I know this is not your bill, that you weren't on it, but on this agenda, there's 3 HPD initiated bills. So, okay, well, hopefully, can you see if whoever was initiated this bill can get back to the committee or the committee chair so he can get back to us? Sir?
It will definitely get our rep HPD to forward the committee the updates, and they're submitted their written testimony, but unfortunately they submitted it late. So.
Oh, okay. Okay, thank you. Thank you, Chair.
Okay, thank you. Members, any other questions? If not, moving on to HB 172 relating to offenses against property rights. First up, we have the Office of the Public Defender, William Bento.
Good afternoon once again, Chair, Vice Chair, William Bento of the Public Defender's Office. The Public Defender's Office opposes this bill. We've submitted written testimony and we'll stand on that, but we will be available for questions. Thank you.
Okay, thank you. Next up, we have the Maui Police Department, Victor Ramos. All right, Mr. Ramos is not present. Next up, we have Honolulu Police, Mikhail Kunishima.
Good afternoon, Chair. I'm Michael Kunishima, Captain with the Honolulu Police Department, Criminal Investigation Division. The Honolulu Police Department supports this bill. We stand on our written testimony. It'll just give the law enforcement a better tool on holding people who steal cars or driving stolen vehicles accountable for their actions. By making it recklessly and negligently, I think that out of the 3,000 cars a year that get stolen, only about 500 to 600 of those vehicles are caught with a suspect driving it, and less than half of those are charged due to the intentionally and knowingly state of mind and the difficulties we have and the prosecutors have in charging the cases. So you would think just that small percentage of suspects caught driving stolen vehicles and they're never held accountable for their actions. So that's why HPD supports this bill. Thank you. We're here for any questions.
Okay, and members, that's the last testifier. Any questions? Representative Ward.
Thank you, Chair. HPD, in the bill, it says the propelled vehicle means an automobile, airplane, motorcycle, motorboat, or other propelled vehicle. I have not been informed that airplanes are being stolen in Hawaii, or are they? And this bill kind of brings it to the fore. We should be aware of that.
Thanks for your question, Representative. If they are stolen, we have a law that we have in effect to address that.
Okay, this is anticipatory. You're not saying that there's airplanes that have been stolen and we got to catch up with it by putting it in statute.
No, it's just a standard definition that we have for all propelled vehicles. It includes golf carts, other things like that. Thank you.
Mopeds are included in this one?
Yes.
What about new electric street scooters?
That's anything that's propelled, yeah.
It's propelled. Okay, thank you very much. Thank you, Chair.
Members, any other questions? Right, if not, moving on to HB 181 relating to the definition of property. First up, we have the Department of the Prosecuting Attorney in support.
Just briefly, Chair, Deputy Prosecutor Tricia Nakamatsu, on behalf of the Honolulu Prosecuting Attorney's Department, this bill is part of our legislative package, and we thank you, the Chair, for hearing it. We'll stand on our written testimony. We're available for questions, if any.
Thank you. Next, we have Honolulu Police in support.
Good afternoon, Chair. Again, this is Captain Kunishima with the Honolulu Police Department. The Honolulu Police Department also supports this bill in its current state. We're here for any questions. Thank you.
Okay, thank you. That's all the testifiers we have. Members, any questions? Right, seeing none, moving on to HB 177 relating to sexual assault. First up, we have Office of the Public Defender in opposition.
Good afternoon, Vice Chair, Chair, and the members of the committee. My name is James Todd with the Public Defender's Office. The Office of Public Defender will stand on its written testimony in opposition, and we are available for any questions afterwards. Thank you.
Okay, thank you. Next, we have HPD in support.
Good afternoon, Chair, Vice Chair, and members of the committee. Randall Platt, Captain with the Honolulu Police Department. We stand in support of the bill on our written testimony, and I'll be available for any questions. Thank you.
All right, members, that's all the testifiers we have that are present. Any questions? Representative Ward.
The Public Defender. In your testimony, you seem to nuance, or let's say that the term mentally defective is the trigger that trips up your support of this bill. Is that correct? Because of the definition of mentally defective?
Oh, well, mentally defective, you're talking about this. We basically think our thrust of this is that the law is unnecessary. The combination of the term mentally defective definition as well as the ineffective consent law that we have, most parts we don't need this law. We just don't like the strict liability because it's just a whole blanket prohibition there. So we would like cases to be decided individually, and there could be certain circumstances, as well as, and I think to your question here as to the mentally defective, it is trying to put this group in the same as inmates, and then we distinguishes inmates have an end date, as well as minors. You know, once they reach majority, they're no longer minors. But mentally defective, there is a possibility that a person may be mentally defective one point and may not be mentally defective another point, and go back and forth and whatnot. And the knowingly portion, I think it protects the defendant from.
Thank you. Thank you very much. Okay, Officer Platt.
Sure.
Why do we need this bill in your view?
The mentally defective is a segment of the population that is extremely vulnerable to being preyed upon by sexual predators who in fact target and take advantage of individuals like this. So we feel that they're a class or a section of society that absolutely needs our protection.
Is this anticipated, or there's actually a, how would you say, an experience rating out there that there's a lot of mentally defective people that are being taken advantage of?
Again, it's hard to actually quantify it, but working with the prosecutors, they face challenges in prosecuting cases like this because, again, that definition of mentally defective is so wide. But clearly, for someone who's not able to understand what their actions are and are very easily led and taken advantage of, it's those people that we need to protect.
Is that under or without drugs? That seemed to be the biggest mentally defective. Well, no, that's.
I'm sorry, sir, but without drugs.
Thank you very much. Thank you, Chair.
Okay, thank you. Any other questions? All right, if not, moving on to HB 250 relating to sexual assault. We do not have any testifiers for this present. Members, anyone want to take a shot in the dark? Okay, if not, moving on to HB 887 relating to crime. First up, we've got the Attorney General's office in support.
Thank you again, Chair, Vice Chair, members of the committee, Deputy Attorney General Fashad Tawebi, Human Trafficking Coordinator, and the department stands on our testimony, and I'm here for any questions. Thank you.
Okay, thank you. Next, we have the Office of the Public Defender in opposition.
Aloha, Chair Nakashima and members of the committee, Deputy Public Defender Darcia Forrester. The Office of the Public Defender opposes this measure for several reasons, as discussed in our written testimony. I would like to highlight that we strongly oppose strict liability as to the state of mind and attendant circumstances that a victim was in fact a minor. Subjecting a person to a Class A felony with a punishment of a 20-year prison term should require some actual intent, knowledge, or recklessness as to the age of the person who may have purported to be an adult and who may have even provided documentation like a fake ID to support their status as an adult when engaging in a transaction for sex. In addition, we have serious concerns about the broad language of the term any item of value without some qualification that the intent is to participate in a business transaction for sex, as opposed to behavior that would be considered flirting, courting, or dating in the modern context. We live in a world where hookup culture is a thing. Dating apps bring people together for sexual encounters, and we should not criminalize a consensual sexual encounter because there was an agreement to have sex after something as innocuous as a meal or a beverage is purchased. Thank you very much, and I'm available for questions.
Thank you. Last, we have HPD in support.
Yes, Chair and committee, thank you. Major Philip Johnson, Honolulu Police Department in support. I'll stand on our written and available for questions if needed.
Okay, thank you. Members, any questions? Okay, if not, moving on to HB 975 relating to reports of child abuse. First up, we have Department of Human Services in support.
Chair, Vice Chair, and members of the committee. I'm Daisy Hartsfield on behalf of the department. I'm the Social Services Division Administrator. I just have one minor correction to make to our testimony. We not only stand in support, but we stand in strong support of this bill. Otherwise, I stand by everything else submitted, and I'm available for any questions. Mahalo.
Okay, thank you. That's all the testifiers we have. Members, any questions? Seeing none, moving on to HB 980 relating to adult protective services. First up, we have the Department of Human Services again in support.
Aloha again, Daisy Hartsfield on behalf of the Department of Human Services. We stand by our written testimony, and I'm available for any questions. Thank you.
Okay, that's the last testifier we have. Members, any questions? If not, moving on to HB 571 relating to childlike sex dolls. First up, Oh, we do have one. First up, we have HPD in support.
Good afternoon again, Chair, Vice Chair, members of the committee, Captain Platt with the Honolulu Police Department. We stand on our written testimony in support of this bill. I'll be available for any questions. Thank you.
Okay, thank you. That's all the testifiers we have. Members, any questions? All right, if not, moving on to HB 1326 relating to domestic violence. First up, we have Office of the Public Defender in opposition.
Good afternoon, Vice Chair and members of the committee. My name is James Tue with the Public Defender's Office. Before we stand in opposition of this testimony, I just want to point out a few things here. Number one, I just cannot see how a statement, even if this measure passes and this exception is created, how it would survive the confrontation clause under the Hawaii Constitution. It is testimonial, and it will. The statement cannot come in at this point. And the second point I have, which may not have been addressed in our testimony, is that it seems that this exception is premised on a ongoing emergency as I guess they classify domestic violence as an ongoing emergency. But if you take a look at what would happen on an arrest or on a domestic violence situation, the police officer would arrive, they would arrest the individual. The individual is taken away. This individual is also given what we call the 48-hour notice here in Hawaii, where they're not even supposed to be in contact with the so-called victim during that time period, within that 24-hour time period. So we don't understand how the emergency is ongoing once the defendant or the alleged perpetrator is removed and is removed for 48 hours. So other than that, we would stand on our testimony in opposition, and I am available for any questions afterwards.
All right, that's the only testifier we have. Members, any questions? All right, if not, I do have a question for the public defender. Your concerns about the confrontation clause are noted, but this bill is creating a hearsay exemption, which, I mean, I have a hard time thinking of any hearsay exemption that requires confrontation. I mean, I'm thinking dying declaration is one that is testimonial in nature as well. So given that it's a hearsay exemption, I don't understand how that's a conflict, unless you're saying all hearsay exemptions are a conflict with the confrontation clause in the Constitution.
No, well, no. But see, as for the dying declaration, it's that statement is not made for like in the preparation of the trial, so to speak. As anytime when you talk to a police officer, especially on an alleged crime, it is what we call it's what we call testimonial, because statements out of court could be either testimonial or non-testimonial. And then there's, if you read the cases, it gets muddied, the definitions. But in this situation, it's clearly when a victim of domestic violence makes a statement to the police, such as, you know, my spouse hit me, that is going to be supposed to be used in court. That is testimonial. Therefore, if it's testimonial, it may survive this hearsay exception. But once the confrontation clause is, once we raise that, the defendant has a right to confront the witness, seeing if the statement is true and correct, credibility, you know, judge credibility, the whole bit. It's just not going to survive because it is testimonial. I mean, I cannot see a judge letting it in, and if it does get let in, I cannot see how the appellate courts are going to overrule it. We're just going to have to do this trial over again if the statement does somehow get in at this point, when the defendant never had the opportunity to cross-examine the witness about this statement.
Okay, thank you. I wish the other testifiers were here. Thank you. Moving on to HB 1237 relating to the judiciary. Looks like we do have one. Honolulu Police Department in support.
Good afternoon, Vice Chair, Chair, and members of the committee. Again, Captain Platt. We stand in support of the bill, and we have submitted written testimony. I'll be available for questions if there are any.
I'm sorry, members. Yeah, that's the only testifier we have in support. Any questions? All right, seeing none, moving on to HB 566 relating to abuse of family or household members. First up, we have Office of the Public Defender in opposition.
Aloha again, Chair Nakashima and members of the committee. The Office of the Public Defender strongly opposes House Bill 566. We have outlined in our written testimony a number of serious issues we have with this measure. However, I would like to highlight that we have constitutional concerns about the overbroad language, the overbroad definitions, and the overbroad scope of this measure as it's currently written. We understand the intent, but this measure will criminalize normal disagreements that family and household members may have. We are also very concerned about the ease that this measure, as written, may be used as a weapon to further establish power and control over a person who's already experiencing abuse. We strongly urge this committee to look closely at the definition of coercive control under HRS section 586-1 and review our written testimony, which outlines a number of examples. We provide examples of how a law-abiding citizen can get caught up in the criminal justice system and accused of the crime of abuse based on behavior that we believe should not be criminalized. In essence, we just feel that the definition of coercive control is too broad and will bring in behaviors and criminalized behaviors that we think maybe the legislature does not necessarily intend to criminalize. Thank you very much, and I am available for questions.
Okay, thank you. Hawaii State Coalition Against Domestic Violence in support.
Good afternoon, Chair and Vice Chair. I'm Angelina Mercado of the Hawaii State Coalition Against Domestic Violence, and I stand on submitted testimony in support of this bill, and am available for any questions you may have.
Okay, thank you. We have HPD with comments.
Again, Vice Chair, Captain Platt with the Police Department. We submitted written testimony. We have concerns about the bill, particularly with the definition of coercive control. They're outlined in our written testimony. I'll be available for questions if there are any. Thank you.
Okay, thank you. That's all the testifiers we have present. Members, any questions? Representative Ward.
Thank you, Chair. The Coalition Against Domestic Violence, do you have any baseline figures of where it was last year or the year before and where we are now in terms of the increase that we're noting is happening with domestic violence?
Thank you, Representative Ward. So we have some data that we're in the process of collecting from our programs. And so what we are seeing is across the board increases in calls to the domestic violence hotlines. So we know that most of our citizens live here on Oahu. So some of our programs on Oahu are seeing at least an 25% increase on calls. And on their hotlines, programs that have multiple services with their clients will see 300% increase in contacts with their clients. So that means they're constantly talking to them about their cases, whether they're working on legal cases, TRO, supportive services, etc.
So 25% calls is equivalent to 25% increase in violence, or not necessarily? Not necessarily.
Not at all necessarily an increase in violence. So, I think you're trying to get a picture. excuse me if I'm getting this wrong, but I think you're trying to get a picture of what impact the pandemic has had on survivors of domestic violence. And we know that at the very beginning of the pandemic, it was not clear to survivors that they could leave their homes or seek outreach services if they were experiencing violence. So we know that survivors didn't think that there were services available to them. They didn't think it was safe for them to seek shelter. And with also having their abusers in the home with them, it wasn't actually possible for them to have the privacy and the timing that they might actually have under normal circumstances to make a call for outreach. So for instance, if a survivor has a different schedule than her abuser, that abuser perhaps is away from the home, they're working. Well, now if that abuser is now in the home with them, they don't have access or time or space to perhaps make that call to a program or a shelter or a hotline, whether national or locally in the state.
Speaking of normal circumstances, the public defender suggested that we are possibly criminalizing normal marital conversations or something to that effect. Do you have any comment on that?
Sure. The distinction for domestic violence and what might be a behavior between any romantic or intimate partner relationship is the distinct pattern of power and control. So it's the pattern where the abuser intends to have control over the person in their lives. It's not just about, I may disagree about you with something and perhaps we don't have really great communication skills. It's about the person having the intent to control every aspect of their lives. And that could result in not letting them seek medical services, controlling their whereabouts, controlling their finances, not allowing somebody to have access to their own personal bank accounts, or if they do, they monitor every aspect of their personal bank accounts. And so there has to be a distinct pattern. And I'll also note that coercive control is actually a definition and something that is actually monitored by the Centers of Disease Control and Prevention in this country. And it's stated that they do capture in their in a national survey that they conduct. And so when they did a survey on a state-by-state basis, they did find that about 45% of women in Hawaii have experienced coercive control, some form of coercive control, and about 41.8% of men in Hawaii have experienced the same.
Oh, thank you. Thank you, Chair.
Okay, members, any other questions? Representative Nakamura.
For HPD, please. I have a question about, seems like you're raising the concern about how to define coercive control with respect to isolating the individual from friends and family, and then financial, controlling how much money is accessible. So are you saying that further definition is needed to help guide HPD?
Yes. The definition of coercive control as it's written, we find it to just be broad, very subjective in terms of the officer who has to enforce it. And then once we pass that case over to the prosecutors, how they will interpret it as well. So I mean, we support the intent of the bill, but the definition is what's troubling for us.
So if there's a clear definition, then HPD would have better guidance and probably better results?
Yes. I think it would be clearer or easier to enforce if, again, those guidelines were in place by the statute.
Okay, thank you very much. Can I have a question for, was that Angelina Mercado? Who was the person we were talking to?
Yep, that was me, Angelina Mercado.
Hi, Angelina. Do you agree that the definitions are too broad for enforcement purposes, that tightening it up would be helpful for you as well?
So when I compared the definition, I actually took a look at how the CDC looks at the definition and found that what we have included in our definition is consistent with what the CDC looks at from a psychological aggression So when they look at that data about psychological aggression, it includes insulting, name calling, etc., that we include in our definition of coercive control, as well as the behaviors that reflect monitoring, controlling, and threatening. So I think that the definition as written is sufficiently broad to capture all the types of behaviors that abusers would inflict on their partners.
Okay. Seems like there's thank you very much. Appreciate it. Thank you. Thank you, Chair.
Okay, thank you, members. Any other questions? If not, moving on to HB 940 relating to securities. First up, we have DCCA in support.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Tue Feb, the Securities Commissioner with the Department of Commerce and Consumer Affairs. We have submitted written testimony to the committee in strong support of this administration bill. We also are requesting amendments in order to accommodate the comments received by the Department of Human Services. We also wanted to note that we have submitted to the committee for consideration a proposed HD2, which reflects the consensus language reached with Department of Human Services. Thank you for the opportunity to testify, and I'm available for any questions.
Thank you. Next up, we have DHS with comments.
Hello again, this is Daisy Hartsfield on behalf of the Department of Human Services. We did submit written testimony, and we are appreciative of the collaborative efforts with DCCA in considering the proposed amendments. Our written testimony provides an explanation as to why we believe the amendments are necessary, and I'm available for questions. Thank you.
Thank you. Next up, we have NAIFA Hawaii in support. Cynthia Takinaka, are you there?
Can you hear me? I'm sorry. Good afternoon, Chair. Good afternoon, Vice Chair. Cynthia Takinaka, National Association of Insurance and Financial Advisors. We are in strong support of this bill, and we don't have any objections to the amendments proposed by Department of Human Services and Tai Nohara. We urge your support of this measure. Mahalo.
Okay, thank you. That's all the testifiers we have. Members, any questions? Okay, seeing none, we are moving on to everybody's favorite, HB 534, relating to use of force and self-protection. First up, we have HPD in opposition.
Vice Chair, Chair, and members of the committee, again, Captain Platt with the Honolulu Police Department. We have submitted written testimony. We are in opposition to this bill, and I'll be available for any questions afterwards.
Yep, thank you. Next up, we have the NRA in support.
Yes, Mr. Chair, members of the committee, for the record, Dan Reed, Western Regional Director with the National Rifle Association. We're here in support of HB 534. We stand on our written testimony. I offered 2 clarifying amendments, which I think provides a little bit more clarity and fluidity to the bill. With that, I'll stand for any questions. Thank you.
Thank you. Next up, we have Everytown for Gun Safety in opposition.
Aloha, my name is Melissa Pavlicek, and I'm testifying in strong opposition to House Bill 534 on behalf of Everytown for Gun Safety. More than 6 million moms, mayors, teachers, survivors, gun owners, students, and everyday Americans, as well as many of us here in Hawaii, have come together to make our community safer. We've testified many times over the last several years, and we oppose this bill based on our work to make Hawaii safer. Stand your ground bills do the opposite. This bill seemed to move under the premise that people need this legislation to protect themselves. They already have that right under current legislation. Expanding those rights, as this proposed bill would do, is very alarming, and we ask you to please not advance it. Over the last 4 years, as I have worked closely with many members of the Hawaii community to support gun violence prevention, I've met and spoken with community members here in Hawaii and here in Honolulu who have been shot, including one who survived being shot 5 times. Just today, I spoke to a member of the legislature who lost a young man who the legislator mentored to gunfire. Please do not pass this bill. A study comparing the 5 years before states began acting stand your ground laws to the 13-year period following their enactment found justifiable homicide rates increased by 55% in the states that enacted stand your ground laws, while these rates increased by 20% in states that did not have such laws. There are a number of other statistics in our testimony, and you'll hear from other organizations that we work closely with, like Moms Demand Action for Gun Sense and Students Demand Actions for Gun Sense, right here from our Hawaii youth who are strongly opposed to this bill. Please do not advance it. Thank you.
Thank you. Next up, we have Hawaii Moms Demand Action in opposition.
Yes, good afternoon, Chair, Vice Chair, members of the committee. My name is Carolyn Pearl, and I am a member of Hawaii's Moms Demand Action. This bill is being sold as a matter of self-defense, and the unintentional consequences are deadly serious. We don't have the death penalty here in Hawaii yet, but House Bill 534 will enable any person who feels threatened, which is a very subjective emotional state, to act in the moment as judge, jury, and executioner without accountability for their actions. Please do not advance this bill. We strongly oppose it. This will not keep Hawaii safer. Thank you.
Thank you. Next up, we have Hawaii Firearms Coalition in support.
Good afternoon. My name is Andrew Namiki Roberts. I'm a director for Hawaii Firearms Coalition. And I just want to clarify some things that have just been said. So they keep referring to this as a stand your ground bill. This bill is substantially different to other states that have a true stand your ground bill. In those states, it allows a person to use force without having a direct need to. So it's on a simple belief. In Hawaii, our current law already has that belief in it. So when you say you need to believe that you were in fear of violence, that's what the current law already says. So if they're saying that that's the problem, that law's been in place since 1975. In 1975, they passed this, Hawaii's current self-defense law that says that you can use deadly force if you believe that you're in fear of rape, serious bodily injury, death, or kidnapping or sodomy. Those five items are still in position in this law. The person still needs to believe that those things are going to happen. What this bill does is it clarifies that if a person does use deadly force or does use any force, it means that they can't face criminal prosecution for that. They get a fair opportunity to present themselves before a trial so that evidence can be presented to say why it was illegal. Also, another thing that's addressed in this bill is that the person has to be in a place that they can legally be and not committing another crime. So a lot of the testimony is talking about people with illegal firearms. If they have an illegal firearm, they are already committing a crime, in which case this bill would not apply to them. They would still face criminal charges under this bill. If they are harassing somebody or they start an argument with somebody and they've committed a crime at the very beginning of this to instigate a situation where they can use deadly force, again, this bill does not protect them. What this bill does is protect people that are going about their lawful day and they come into a situation where their safety is threatened and they're forced to use any kind of force, not just deadly force, because this bill covers pushing, shoving, kicking, up to deadly force, which obviously is a last resort.
Sorry,
Yes.
the 2 minutes is up. Can you summarize and conclude?
I wasn't aware that a 2-minute limit was set at the beginning of the hearing. My apologies. So just to summarize, Hawaii's current law already allows for deadly force to be used. This law clarifies that a person that uses it lawfully and legally won't face criminal or civil charges. That's all that's included in this bill.
Okay, thank you. And last up, we have Stolen Stuff Hawaii in support. Mr. Kitchens, if you're there. Mr. Kitchens, you're muted.
Okay, good. Sorry, technical difficulties there. Chair, Vice Chair, thank you for the opportunity to speak. I run Stolen Stuff Hawaii, which is an anti-crime community group on Facebook and Instagram. We have over 138,000 members. And since 2014, I have been witness to unbelievable amounts of crime reports directly from the victims themselves. Having run this group for over 6 years, combined with the effects of the recent pandemic, what we've seen recently is there has been a massive amount of crime from the victims being posted and shared to SSH. It's been utterly demoralizing, and it's essentially nailed home the idea that we're dealing with something that's out of control right now. My members feel unsafe. They have no defense against criminals right now. In fact, all of the laws in the legislature seem to put put it in the criminals' favor. When it comes to ourselves, we're obligated to retreat. We're obligated to give up our possessions, unless we're in our homes. We have so many people that have been victimized on the street, walking to their car, walking to their destination. They've been robbed. We've had elderly, killed in the middle of the street. And really, we're prohibited the tools necessary to defend ourselves. The only thing we have to defend ourselves is pepper spray. And criminals have become so brazen. They're already aware that they're not being punished. They're not being prosecuted now. We have numerous examples being shared in our group that show that criminals are not being charged. They're not being held accountable for the actions that they take against our members. This is quite literally one of the worst situations I've ever seen. I've lived all across the United States, and I've never seen crime being committed against people and then people not being charged. I know it's directly related to the COVID situation and the pandemic, but our members are scared. What this bill, I believe, does is it gives, I'm sorry.
Mr. Kitchens,
I believe it gives.
Summarize and conclude.
Okay. To summarize, this bill gives our members a chance for self-defense. It's not a gun bill. It's a across-the-board self-defense bill that gives them the opportunity to protect themselves, their property, and their loved ones. And I highly support it. Thank you.
Next up, we have Michael Tanawai. Not present. We have a bunch of individuals. I'm just going to be calling the people who said they were going to be here. We have an individual in support, Cass Nakasone.
Thank you for allowing me to be here. I strongly support this bill for a very simple reason, is that like Mr. Kitchens said, that the people need freedom to protect themselves. I think lack of support of this bill implies to me that our legislators and our police officers can somehow guarantee individual citizens' safety. And that's just not possible. We've called police to our neighborhood several times for break-ins, and it takes at least 15 minutes. I think that it's ridiculous to expect people to not have the capacity to protect themselves. Or we change our laws to make it that the legislatures who don't support self-defense become personally responsible for our safety. If you are saying that you are guaranteeing our safety, then I think that should be guaranteed, and that should be, people should be held accountable for that, because clearly the criminals are not, and the criminals do not respect boundaries. So I highly support this bill because it just allows people to be able to defend themselves in any practical situation. From what I understand of the laws, that if somebody breaks into your house, you have a duty to retreat. You may not have the opportunity to retreat. And I just don't understand, I don't understand how that can be reasonable. So I highly support this bill, and thank you for allowing me to testify.
Thank you. Next up, we have an individual, Ruben Betts, in support. Not present. Eric Ako, in support. Okay, not present. Dan Gu, in support.
Hello, can you hear me?
Yep, we can hear you.
Hi. I'm a retired detective from the Honolulu Police Department, and I'm currently a contractor for the U.S. Marshal Service. I've been in law enforcement for 35 years, and I strongly support this bill. When I was a young kid, I remember taking 2 quarters to school, one in my pocket and one in my shoe. And the reason why I hid one in my shoe is because if they take the quarter from you for lunch, you would have another quarter. So when I graduated in criminal justice, I said, you know what, I'm going to join the police department. I'm going to fight crime. I'm going to help people. I'm going to help my community. I'm going to save my community from all this unjust. Well, shortly after a year of being in the police department, I realized that I could never help anyone. I could never help a rape victim. I never helped a murder victim. I never helped someone who got robbed for a quarter with their broken mouth, broken nose, swollen eye, and having a concussion, because I could never get there in time. I've been to like 5 bank robberies, and I never got there on time when the suspect is still there. So I strongly support this bill because we need protections and we need the tools to be able to protect ourselves. Because if we don't have the tools and we don't have the backing, then we just become victims. It's just, you have to protect the community, and one of your jobs is to help us to be able to protect ourselves. Because as a law enforcement officer, I was only a report taker. I never got there to any crime to prevent anybody from getting raped, murdered, or beaten. So I strongly support this bill.
Okay, thank you. Up next, we have Chris Tam in support. Okay, not present. Al Elkins in support. Okay, not present. Oh, I'm going to butcher this name. Soleil Rochard in support.
Hi, thank you. My name is Soleil Rocher. You were really close, so thanks. I work for Active Self-Protection. We educate millions of people on moral and legal self-defense. I'm also a certified deadly force instructor and a certified firearms instructor and a certified pepper spray instructor. I strongly support HB 534. This hearing today actually falls on the 1-year anniversary of the day that I had to defend myself and 2 children in my care from an aggressive man experiencing a violent psychotic episode in Kaneohe. Because I am trained and because I was prepared that day, I was successful in defending myself and the kids that were with me. And the man that attacked us was later apprehended by police. They showed up about 5.5 minutes after I had already de-escalated the situation and taken care of it, and he backed off and left us alone. Working at Active Self-Protection, our company, we have analyzed upwards of 30,000 defensive encounters, everything from home invasions to carjackings, robberies, road rage incidents, kidnappings, you name it. And one of the major patterns that we have been able to siphon out of those thousands of encounters is that you are your own first responder and no one is coming to save you. You are on your own. Every human is of inestimable value and worth because we're all bearers of the image of God. Because every one of us are innately precious, our lives should be vigorously protected. We as a community should take every measure to support public safety and give Hawaii's people not just the permission to defend themselves, but also the tools to do so. Self-defense is a human right, and instead of allowing criminals to flourish, the innocent in our community should be fiercely protected. Our laws should reflect those values. The law-abiding people of Hawaii should not have to hesitate to defend ourselves for fear of prosecution, for the justified use of force against criminals who want to victimize us and who have no respect for us or the laws that govern our state. Thank you.
Thank you. Next, we have Todd Yukutake in support.
Aloha, committee. Todd Yukutake. I strongly support HB 534. And this is a victims bill. Victims are faced with several traumatic ordeals in an incident. for one thing, they're a victim of a violent crime. And like was said before, police aren't coming to save you. If you were to injure the criminal too much, you're going to be arrested and face a criminal trial yourself. And thirdly, after that, you face a civil lawsuit from the criminal or their family. And that's happened a lot before. So you're the victim three ways in an incident. Currently, government can't stop these problems, as well as said before. So you have to do it yourself. It's almost as if criminals have more rights than victims do. Let's see. So basically, the people of Hawaii want changes to reduce crime. So punish criminals and save the victims, not just from the actual crime, but from arrest and civil lawsuits and hardships that come from that. Attached to my testimony, I have two things. One is a story from Aloha Tattoo. It was a robbery incident 2 years ago in Kailua. Basically, a gang of thugs was going around Oahu beating and robbing stores and people. They went to Aloha Tattoo, probably tried to rob it, got into a fight with the owner. Owner put out a knife, stabbed one of them. That one guy staggered out with his friends, and he passed away. The news story said he was arrested on site, but later released because of our current protections in our workplace. But he can still get sued from the victim's family, or from the criminal's family, sorry. And what's even more alarming is if this occurred on the public sidewalk outside of his store, he would have been arrested and put in jail right now because he would not have any protections in public. And that's something that this bill does. It fixes criminal and civil liabilities, and like was said before, eliminates the having a retreat too.
Thank you, Mr. Yukutake. That's 2 minutes. Could you please conclude? And noise.
Also have SB 334 attached to my testimony that reimburses legal fees for self-defense incidents. Please consider that too, maybe merging it with this bill. Or I know there may be some problems in this bill, so incorporating changes from that bill into this one. But I strongly support SB 334. HB 534. Thank you.
That's all the testifiers we have today. Members, any questions? Representative Ward.
I yield to Maui. Go ahead. I'll start off. Excuse me, but it's the gentleman with the British accent who has a beard. I can't remember his name.
It's okay.
Sorry about that.
Pretty accurate description.
That would be Andrew Namihi Roberts. Yes.
Is the issue here that we're talking about, the law now, as you stated, you can actually do all of that stuff. The only difference is you're going to be prosecuted when you do. You're not going to get off.
So that's a significant part of what this bill does, is it removes the criminal and civil liability for somebody that lawfully uses self-defense. The other part of the bill means that somebody can use self-defense outside of their home or place of business. It opens up self-defense to all locations. So if you're attacked in the street or you're attacked in the parking lot of your building, you're now covered under this. Under Hawaii's current law, dwelling only defines the 4 walls of your property. So if, for example, you were attacked in your driveway or in your front yard, you would not be protected under the current law.
Okay, so the question is, of those who do get prosecuted, what's the amount where I'm trying to look at some metrics. For those who defend themselves, and then they end up getting sued and fined or put in jail, versus those who actually are allowed under the present law to do what they're doing, what's the ratio or the amount of people who are punished for defending themselves? The right to defend themselves actually gets punished. What are the numbers?
From my understanding, speaking to Honolulu Police Department, anybody that uses deadly force is going to be arrested and charged, and then later down the line, the prosecutor will make a decision on whether it's lawful under the law. So once they get arrested, speaking to self-defense lawyers in Hawaii and criminal lawyers in Hawaii, just that initial arrest would set somebody back $25,000 to $50,000. Whereas with the protections in this law, the proponent of evidence would be on the prosecutor before the person can be charged.
Okay, thank you very much for that. In fact, I would ask the HPD or retired Officer Gu. In fact, Chair, one of the officers had, I think, another witness or another testifier. Officer Gu, retired Officer Gu, are you still there?
Yes, I'm still here. My wife submitted testimony. I wanted to testify, but we only have one computer, so that's why she's not on the list.
Okay, with the chair's permission then. Mrs. Gu, or one person with retired Officer Gu wanted to testify.
HP for HPD.
No, it's the retired HPD's friend or spouse. I forget which it is.
Yes.
I think that might be my auntie. Yep, I think she could.
Okay. Mr. Gu, please proceed. Oh, there you are. There
Thank you. That's correct. I am your auntie. I really wanted to physically testify today because although I did a testimony in writing, oftentimes the mere presence is so much more important. I wanted to let you know that I recently got more involved and I've developed a group called Advocacy for Women for Self-Protection because there's been numerous occasions that I've witnessed that really have not sit right with me. I've been a resident of Kaimaki for 50, 60 years and I've seen the crime just escalate. My father has ringed and I also saw someone come to his door and ajar the door, knock in. Someone tried to come into his house. He lives alone. He's 90 years old. I have been actual witness to 3 robberies on our street where they've been robbing the houses right around us. And I also saw someone climb over our fence in an attempt to rob us. So we try to do as much as possible for protection, but I do believe that this bill does protect us one step further because you are able to protect yourself without criminalization. And I think that's very important. As a vulnerable person, I think the more I can have to protect myself, the more important. And I really want to speak out in this because as an individual in the community, in the parking lots, recently I want to tell you about an incident that strongly has affected me. January 4th, 2020, First Interstate building, woman in the elevator by herself, door open, 38-year-old homeless man on drugs, blocked the elevator. She could not move, could not get out, and raped her in the stairwell. You're probably well familiar with this incident. He raped 2 people. Now, deadly force maybe, but force yes. If she was able to defend herself, I think she would have been far better off than just standing in an elevator with 3 walls around her. Thank you very much. I appreciate the time, and I really appeal to you to pass this bill and say yes. So thank you.
Yeah, thank you. Representative McKelvey, did you have a question?
Well, yeah, a question of Melissa Pavlicek, if she's still on at all.
Oh, yes, Brett McKelvey.
Yeah, I'm looking at at section 2, the number 2, subsection A, and I'm thinking about the scenario earlier where the woman said that they encountered the hostile homeless person. Under this bill, you're occupying the premises of a place that the actor has a legal right to do so. So considering that, say, a homeless person has a legal right to be in a park and a confrontation developed and they pulled out a gun and shot the person, would they still be charged under this law? Could they now claim this defense? Because you've taken out all of the bodily, imminent threat elements that exist under the existing law.
I'm looking at the section that you're pointing to, and I think it refers to the person who is using violence to defend themselves. So I'm not sure, but to kind of expand on where I think you're asking, which is this bill going too far in the guise of helping people defend themselves? And I strongly believe that it is. One of the key differences between this bill and the existing law is over the protection of your property. We heard many other testifiers say today they are concerned about their property. We already have in our statute the ability to protect ourselves when we ourselves are under threat of bodily harm. So I'm very concerned that we're now expecting individuals to be wielding firearms to protect property when, as another testifier said, they're serving as judge, jury, and executioner all in one fell swoop. So I'm not quite sure if I answered your exact question. I apologize, but I am not very deeply familiar yet with the way this bill has been amended, but I am very concerned about it and thinking through all the ramifications and the negative impact about increasing violence in our community.
No, that was actually what I was trying to get at, is the unintended consequences potentially that could be there. So thank you. Thanks, Chair.
Okay. Members, any other questions? Representative Lowen.
Thanks. I guess for HPD, if you're still on, I just wanted to give you a chance to answer the question that was asked earlier of someone else, which was how many incidences do you have of somebody being charged with use of deadly force where, you know, their right to self-defense wouldn't have been more relevant anyway?
I'm sorry, I don't have any specific numbers with regard to that, but typically the person may or may not be arrested. Again, it depends if there's probable cause to affect that arrest, but the case would, in situations like that, the case would be conferred, and it's the prosecutor's office that would typically decline a case like that. So we have had examples like that, but I can't at this time provide any numbers.
Okay, all right, thanks.
Members, any other questions? Rep. Nakamura.
Yes, for HPD as well. Captain Platt, your testimony suggests that that this law is not necessary because there's already provisions in place for folks to defend themselves. So can you expand on that? If someone were to come into my home and you know, I find them in the process of burglarizing my home, what can I do to protect myself under the current law?
So again, I'm not a prosecutor, so it's difficult in that sense, but reading the section, you don't have, in your home, you don't have a duty to retreat. So you, again, depending on the use of force against you, but you don't have deadly force can be justified in that situation.
Yeah, that's what I see, that's the language that's being deleted in this law, that you know, taking away the provision that you can protect yourself against death, seriously bodily injury, kidnapping, rape, and forcible sodomy.
Right, those are allowed. But our concern is that the wording of the law right now is that deadly force can be used against anyone who intends or endeavors to use basically any type of unlawful force. So two people in a park, push come to shove, there's your force. They can both draw on each other and use deadly force to kill one another. You're basically allowing a gun to serve fist fight. That's our concern, is that it's going to escalate. The use of deadly force is just going to escalate, and it's.
Thank you.
Okay, members, any other questions?
Chair.
Sorry, is that Rep. Lopesti?
Yeah.
Rep. Lopesti, go ahead.
Thank you. Captain Platt, to your example, you broke up a little bit. It sounded like you were saying that we're giving permission to people to draw on each other. Is that what you said?
That's what the law basically allows, as written right now with its language.
How is that a reasonable interpretation? Where does it mention firearms? That we're allowed, I mean, because it clearly doesn't mention firearms.
No,
right?
That's an assumption on my part, but the use of deadly force. So firearms, knives, it could be a number of different.
Right, but that's a big assumption, right? I mean, I'm generally in favor of strong firearms legislation, but this bill doesn't mention anything about that. Now, I was recently in a park 2 weeks ago with my children, and it wasn't a pleasant situation, and I had to call HPD because I was nearly assaulted trying to protect my children. And the cops came after a while, and they said, "Hey, we're glad you stood up to those people who were giving you a hard time, but I also knew that I had a duty to retreat." And you know, if somebody is just out with their family and stands up for themselves, and isn't able to retreat. I got two little kids with me, and the way the statute's written now to prevent kidnapping, is it to prevent my kidnapping or to prevent my kids' kidnapping? I've been in Chinatown in front of the police station and was nearly mugged with my wife. The only reason we weren't is we took 2 steps and we were inside the police station, and the guy actually followed us in there. And they still didn't catch the guy. I mean, I just don't see, I think there's a lot of blown out of proportion assumptions that are being made, but that you just admitted on your own part and that by a lot of other people. You know, I support every town for gun safety. I'm a big supporter of theirs, but this isn't about guns. This is about not having to run away every time some idiot gets in your face, and you can stand up for yourself and your children, your family, and your dignity. I don't see what's wrong with that. And that's, you know, I'm sorry, I'm making a statement, not asking a question. Thank you, Chair.
Thank you for that statement, Rep. Lopresti. Any other members?
One last question.
Rep. Lowen.
Thanks. Is the deputy prosecutor on the call for questions?
Yes, Representative. We had submitted late testimony, I'm sorry, on this matter, which is why we weren't called, I believe, when Chair or Vice Chair was calling testifiers.
Okay, is that okay, Chair? Could you just elaborate on, I guess the question I asked earlier, what I was trying to get at was just how is this law needed, and to what degree, you know, if there is something like a home break-in or something like that, does having this law in place change that situation? I mean, are there many cases where somebody is prosecuted for defending themselves in that kind of situation that you're aware of?
I can't speak to whether there have been or how many cases may have come across where people were prosecuted, whether they're eventually acquitted or whether they were not even charged. As the captain had indicated, that the idea is that those cases would get conferred out once HPD calls us and we have a chance to go over the facts, that if it was a matter of self-protection or protection of others in particular, then those would not be charged. Hopefully the person will not even be arrested as long as the facts support that. We did express very strong concerns about this bill because we see it similar to the way the police are describing, in that it would allow deadly force for anyone who's using unlawful force against you. Now, unlawful force could mean an assault, but understand that low-level assault just means pain. So if someone pushes you and it hurts, that would be unlawful force. And this would allow you then to use deadly force against them, literally. And whether that happens with a firearm, with your bare hands, or with a knife, whatever it is, this bill would allow deadly force in response. We do feel it's going just too far. There were a number of technical issues that we saw with it, and that's mentioned in our testimony as well. But we do definitely feel that it's going too far because people are currently allowed to protect themselves. They're allowed to protect others. Not only in the case of the death, serious bodily injury, kidnapping, rape, or forcible sodomy, but it's a little broader, even if it's in protection of others. You don't have the same duties to retreat that you would necessarily for yourself. And it's based on your understanding of what's going on. Say you come into something and it seems like somebody really needs your help, you need to step in for somebody, you wouldn't have the exact same duties of retreat that if you knew exactly all the facts. Instead, for protection of others, it's based on what you believe the facts, reasonably believe the facts to be. I'm not sure if that answers your question, or if there's other aspects that you're wondering about.
I mean, I guess I'm trying to understand what situation this bill is trying to address that isn't covered under current law. I mean, which I think you addressed that basically.
Just listening to some of the testifiers, it does sound as though there might be some confusion, that people are under the impression they're not allowed to protect themselves. And I'm not sure where that comes from, or I'm not sure, maybe there's different degrees of understanding what their current rights are. But there's clearly an existing duty, a privilege and right to protect yourself and to protect others.
All right, thank you.
Chair,
Members, any other questions? Representative
could I
Ward, you have a quick one.
continue questioning the same witness as earlier, the testifier?
Are there any other
sorry.
members who have not asked a question before who would like to ask one? Okay, Representative Ward.
Should I continue? The question I had in continuation was, is this because of the geographical extension that from your home, now it includes your vehicle and a place you can legally be? And is it that the law says now if you are in your home and in your, I guess it doesn't say vehicle, you can defend yourself using deadly force and not be convicted? Is the issue, the point is, the question, is it geographical expansion that seems to be the rub here?
So the geographical,
Okay.
was that directed at me?
I'm not sure. I'm sorry.
It was the previous testifier.
Prosecutor.
The prosecutor.
My apologies.
Sorry.
Representative, I don't know that that's the entirety of the concern. That is a concern, certainly. That you're greatly expanding the protection of property, the right for someone to use deadly force and protection of property. And that is a policy call. We would certainly encourage the legislature to reserve deadly force more for protection of people, for protection of yourself. There may be cases in which protection of property may call for such force as well, but this bill just goes so far in allowing you to use deadly force for very minor actions taken against you or others, like I was explaining, as far as any form of unlawful force.
Thank you for that. Mr. Dunn, were you going to add something to your testimony?
Yeah, I just want to say that there does seem to be some confusion about, we're talking about property, and this bill, although it uses the term property, it doesn't actually say that you can use force to defend property, in that it still has to be somebody using unlawful force against a person who intends or endeavors to legally occupy a dwelling, motor vehicle for the purposes of assaulting or offering personal violence. So it seems to be that people might be reading different versions of the bill, because there's been some wording changes. I mean, unless I've got the wrong version, but I've just pulled it up on the Capitol website. The bill doesn't allow for force. That's actually, force to defend a property is actually covered under a different section of the law. The main part with this bill is that it removes the limitations on the places where you can defend yourself and where you can use deadly force. Right now, if you use deadly force outside of the four walls of your home or the four walls of your business, you're on your own. The law does not protect you.
That's a geographical exemption. Thank you very much for that. Thank you, Chair.
Okay. Thank you. Any members, any other questions? If not, moving on to HB 490 relating to crimes against seniors. First up, we have Maui prosecuting attorney in support.
Good afternoon, Chair, Vice Chair. Name is Gerald Enriquez. I'm a Deputy Prosecuting Attorney with the Maui County Prosecutor's Office, standing in for Michael Kagami, who got called away suddenly. We stand in strong support of this bill for its deterrent effect because it creates stronger charging options for certain crimes against seniors. To address constitutional concerns, we revised the bill from last year to require that an offender know or reasonably should know the age of their victim, as opposed to the original strict liability intent requirement. We also don't think this bill should require any additional funding beyond what's ordinarily allocated for law enforcement and the judiciary, as pretty much all the conduct there was illegal to begin with. Beyond that, we would stand on our written testimony, and we're available for any questions. Thank you.
Good, thank you. Next up, we have Office of the Public Defender in opposition.
Chair, Vice Chair, members of the committee. I am Assistant Public Defender Lee Hayakawa. While we are opposed to the proposed amendments that single out individuals that are 60 years or older, we are in support of the language which appears to require a knowing or reckless state of mind attached to the amendments. Aside from that, we'll stand on our testimony, on our written testimony, and I'm available for any questions. Thank you.
Thank you. And last up, we have HPD in support.
Good afternoon, Vice Chair. Captain Michael Kunishimo at the Honolulu Police Department. The Honolulu Police Department stands on its written testimony in support of this bill. We're here for any questions. Thank you.
All right, and that's all the testifiers we have on this measure. Members, any questions?
Excuse me. Scott Spillane from the Oahu Prosecutor's Office.
I don't have you here. Oh, I'm sorry. You submitted late testimony. Are we allowing late testimony, Chair? All right, go ahead.
Thank you very much. My name is Scott Spillane. I'm in charge of the Elder Abuse Unit at the Honolulu Prosecutor's Office. We submitted written testimony. I'm in support of this bill. Last year, I testified in person at the Capitol in support of this bill. And then a year later, I have to testify via Zoom in support because this has been a crazy year. Our whole lives have changed in this past year, except for one thing, and that's elder abuse. It hasn't changed. It's still there. I was one of the few people in the office that was in the office every day this past year. When everybody else was able to work at home, I was in the office every day because new cases of elder abuse came in almost on a daily basis. The pandemic did not stop elder abuse from happening. Elder abuse was happening at the same rate as before the pandemic. If you can put on your thinking caps and think of BC before COVID, we had a rash of purse snatchings that were hitting the news. Right before COVID, you had people in Chinatown, people in Kaimaki, people in Mo'iliili walking and having people jumping out of cars, grabbing purses and running away. Now, if you look at the news, you're seeing a rash of home invasions happening involving seniors. Again, elder abuse is happening, and we feel that the package that was originally introduced by the Maui Prosecutor's Office is a good step towards making it dangerous for a criminal to even look at a senior person, a person 60 years of age or older, in the wrong way. Crumbs talk to crumbs. That's what it comes down to. Criminals talk to criminals. When they're locked up together, when they're hanging together, when they're doing drugs together, they realize and they talk to, you know what, who's a good mark, who's an easy mark, what cars are good to break into, what houses are good to break into. Word's gonna get around that if you touch a senior, it's a felony crime. If you touch a senior when it was before a misdemeanor, now it's a felony crime, where before it's a Class C felony, now it's a Class B felony. It's dangerous to engage in a senior when they're the target of your victims. That's what this bill is all about, is adding a little warning sign. Because right now, the only sign a senior has in Hawaii is a target sign over their head saying, that's an easy target, that's an easy target, that's an easy target. I want a warning sign over seniors basically saying, don't even look at them. Don't even look at them. And that's what House Bill 490 is going to say to criminals. Is don't even look at them.
Conclude your testimony.
I'm done. Thank you very much.
Thank you. Members, any questions? All right, hearing none, moving on to HB, last bill of the day, HB 1036, a bill for an act of public safety. We have one testifier, PSD, with comments.
Hi, good afternoon, Vice Chair. I'm Max Latani, Director, Department of Public Safety. We would basically stand on our written testimony, providing comments, and would be here if you have any questions. Thank you.
Thank you. Members, any questions? Okay, hearing none, we will go decision making.
All right.
The Committee on Judiciary and Hawaiian Affairs for decision-making. Members on House Bill 568 relating to sex trafficking, we will defer this measure. House Bill 169, disorderly conduct. Chair's recommendation is that we amend the bill to create an automatic expungement of the first offense after age 18 or 3 years. So at age of 18, the juvenile's record is cleared for any childhood indiscretions. Members, any questions or comments? Seeing none, Vice Chair. Yeah, the first offense. Yeah, so that is only on the first offense. So if you gathered up 3 offenses before age 18, you are out of law. All right. Any other questions or concerns? Not, Vice Chair, as amended.
Chair's recommendation is to pass HB 169 with amendments. Chair and Vice Chair vote aye. Representative Ichiyama.
Aye.
Representative Kobayashi.
Aye.
Representative Lopresti.
Aye.
Representative Lowen.
With reservations.
Representative McKelvey.
Aye.
Representative Nakamura.
WR.
Representative Takumi.
Aye.
Representative Todd.
Reservation.
Representative Tokioka.
Aye.
Representative Ward.
Reservations.
All right, Chair, your recommendation is adopted.
Thank you very much, members. House Bill 170 related to theft in the second degree. Chair's recommendation is that we amend the bill on page 5, line 1. We strike personal from personal value. On page 5, line 2, after including and putting but not limited to. And then finally, technical amendments for clarity, consistency, and style. Any questions, members? Seeing none, as amended, Vice Chair.
Chair's recommendation is to pass HB 170 with amendments, noting the presence of all members. Any members voting with reservations? Representative Lowen with reservations. Any other members voting with reservations? Representative Nakamura. Any other members with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. Members, House Bill 171 related to property crimes. Chair's intention is to kind of reverse direction on that, and on page 2, line 15, instead of deleting knowingly, add to it intentionally, knowingly, and recklessly. So we're kind of expanding it rather than contracting it. Members, any questions or comments?
Sure. I agree with the language. I'm just very curious that what we heard is true today, that 30 to 40% of the people in Hawaii are unbanked. Is that really true to what we know as a committee?
You got to take that to the Commerce Committee, Representative.
Okay, I just thought one of you might know that.
Any other questions or comments? Seeing none, Vice Chair, House Draft, as amended.
Chair's recommendation is to pass HB 171 with amendments, noting the presence of all members. Any members voting with reservations?
Reservations.
Representative Lowen with reservations. Representative Kobayashi with reservations. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 172 related to offenses against property rights. Chair's recommendation is that we move this forward with a House draft with technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 172 with amendments, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 181, House Draft 1, related to the definition of property. Chair notes that this is already defect dated and recommends that we move it forward as is. Members, any questions, comments? Vice Chair, as is.
Chair's recommendation is to pass HB 181 HD1 as is. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 177 related to sexual assault. Members, a proposed House Draft 1 has been circulated to you. It includes a rebuttable presumption of knowledge as a defense for members, and also I'd like to recommend that we defect dated July 1st, 2021. Are there any questions or comments?
Chair, I did not get a draft. Hello?
Yes.
You can hold it up to the camera if you'd like. Okay.
Well, I mean, I just please send drafts to me too if there's going to be drafts circulated. That's all. Thank you.
I'm sorry, Representative. Yeah, we can have a draft sent to you.
Feel free to describe the rebuttal. Or, I guess you already did.
Okay.
I support the chair. I just would appreciate being included. That's all.
Okay. Yeah, my apologies. I will.
Thank you.
Do that in the future. Is there any other questions or comments? Okay, seeing none. Vice Chair is amended.
Chair's recommendation is to pass HB 177 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 250, House Draft 1, related to sexual assault. Chair recommends that we pass this forward with technical amendments for clarity, consistency, style, along with defect date July 1st, 2021. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 250 HD1 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 887 related to crime. Chair's recommendation on this is technical amendments needed for clarity, consistency, and style. Defect dated July 1st, 2021. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 887 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 975 relate to reports of child abuse. Chair's recommendation is to pass this forward as is. Members, any questions, comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass HB 975 HD1 as is. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you. HB 980, House Draft 1, related to adult protective services. Chair's recommendation is also moving this forward as is. Members, any questions or comments? Seeing none, Vice Chair.
Chair's recommendation is to pass HB 980 HD1 as is. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 571 related to childlike dolls. I will note that this is already defect dated. On lines 13 and 15, where initially was 10, I'd like to change that to 5. And the technical amendments for clarity, consistency, and style. Members, any questions or comments? So number of dolls from 10 to 5. Not Vice Chair as amended.
Chair's recommendation is to pass HB 571 HD1 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1326 related to domestic violence. So,
Vice Chair.
Actually, this is the, this is the one. So this way I had it in the wrong place. Okay. House Bill 1326 relating to domestic violence. I don't know, it's defect dated July 1st. I'd like to defect date it July 1st, 2021. Also, note that that these utterances or the statement by the abused is to the responding officer following the incident, and other technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 1326 with amendments. Any members voting with reservations? Representative Lowen. Any other members voting with reservations? Representative Takumi? With reservations. Tokioka. Todd. Any other members? Any members voting no?
No.
Okay, Representative Nakamura? And Kobayashi. Any other members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1237 relates to judiciary. Chair's recommendation is technical amendments for clarity, consistency, and style, and the effect date to July 1st, 2021. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 1237 with amendments. Any members voting with reservations? Any members voting no? Okay, Chair, your recommendation is adopted.
Thank you very much. House Bill 566 related to abuse of family or household members. Chair's recommendation is to defect date this July 1st, 2021. Members, any questions or comments? Representative McKelvey.
Thank you, Chair. The concerns that were issued by both the public defenders and the police officers, I think the fact that both of them agree is kind of telling in and of itself. The CDC is a medical guidance entity. It's not, we're dealing with legal issues and issues of enforcement. So because of that, I thank you for the defective date, but because of that, I want to go reservations.
Okay, thank you very much. Members, any other questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 566 with amendments noting the reservations of Representative McKelvey. Any other members voting with reservations? Representative Takumi. Any other members? Any members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 940 relates to securities. Chair's recommendation is that we adopt the DCCA's proposed amendments and other technical amendments needed for clarity, consistency, and style. Also, the effect date is July 1st, 2021. Members, any questions or comments? Okay, seeing none, Vice Chair.
Chair's recommendation is to pass HB 940 HD1 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 534, House Draft 1. Chair's recommendation is that, Chair's feeling is that the bill is a little bit too much of a stretch, and Chair's recommendation is that we defer this matter for the time being. House Bill 490 related to crimes against seniors. Chair's recommendation is technical amendments needed for clarity, consistency, and style, and effect date the bill July 1st, 2021. Members, any questions or comments? Seeing none, okay.
Chair's recommendation is to pass. Chair's recommendation is to pass HB 490 HD1. I'm sorry, that was with amendments.
Yes.
Any members voting with reservations?
Reservations.
Hey, Representative Kobayashi with reservations. Any other members voting with reservations?
Reservations.
Representative Tokioka. Any other members? Any members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. Finally, members, House Bill 1036 relate to act relating to public safety. Chair knows that the bill does include a specific annotation to the statute, and we'll recommend instead that we blank out the number to 353C dash blank and allow the revisor statutes to determine the appropriate placement of this measure. Also, amendments needed for clarity, consistency, and style. And that's it, members. Any questions or comments? Seeing none, Vice Chair, as amended.
The Chair's recommendation is to pass HB 1036 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much, members. You are adjourned.